Let's couple things before we start. Just about CLS. We are a nonprofit law firm. We are dedicated to advocating, litigating, and educating on behalf of our underserved communities. We are in 5 counties: Maricopa, Yavapai, Mojave, La Paz, Yuma. However, if you are reaching us from any other places in the state, don't worry. We have our sister cities to the southeast, our sister organizations to the southeast, Southern Arizona Legal Aid, and to the north, we have our DNA People's Legal Services. Just a little bit about CLS. Generally, we are here to help people who are low income. However, we have exceptions for certain issues like of tax and victims of domestic violence, also tenants in Maricopa County. We do several types of practice besides this, and every month we have these webinars. They are on different areas. We do things beyond housing, but today we are focusing on tenants. Even in housing, we do foreclosure, habitability, and discrimination. Just a little bit about this presentation. We will be only giving legal information. If you have questions on your specific case, you can always email us if you're watching this on video, or if you're part of the webinar, you can ask and you want to have questions about your own case. We'll show you how to apply for services at the end of this. However, if you have general questions, you can just put it in the chat and we'll get to general questions about the law at the end of this presentation. All right, Jeff, take it away.
Good afternoon, everybody. Couple things. This is set up specifically to deal with the Landlord-Tenant Act. It is not going to deal very specifically with mobile home or Section 8 or anything like that, as it is supposed to be geared to the public and just give a general timeline. So if looking for some more specific information on mobile home, Section 8, that type of thing, that'd be for another time. The Section 8 and public housing timelines vary substantially from what we're going to talk about. Excuse me. And this particular presentation is been put together specifically with the public in mind to give a summary of how the timeline works. So it is not going to go in depth into specific legal issues. It's more to give general information about what happens once you are in the eviction process and what to expect. So that is where we're going to focus on. The first slide, Pam, I think is next. There you go. So very, very important. The word's very quick. Eviction proceedings are what are called summary proceedings. That means that from the time that you get a notice to the time that you end up in court is a very, very short time frame. We're usually talking a matter of days, not a matter of weeks. With that being said, we'll go to the next slide. And everybody needs to be aware that it is not a good idea to stick your head in the sand and act like an ostrich. It is important that once you get that information that something is happening with your tenancy, that you get a hold of CLS or somebody else immediately. If you wait to the very last minute, it is difficult to get help. And as an example I will give is we typically get calls in to our office at 2:30, 3 o'clock on a Friday afternoon for an 8 a.m. hearing on a Friday. In that short a time frame, we are not going to be able to provide help. So it is very, very important to be proactive. Once you get the information and you know that you're having a problem, act immediately.
Jeff, I'd like to step in just real quick. We do have a special program, our tenants eviction assistance project, that it is sometimes able, if they're in the city of Phoenix, to be able to assist people immediately. But still, what Jeff just said, you need to be able to do this quickly, give us as much notice as possible. I just don't want people to not reach out to us if there's a delay. Just reaching in.
Let's jump to the next one. And the next two items are part of what I call my Judge Judy speech. And essentially, if anybody watches Judge Judy, you know that she gets on people for various things that should be common sense, but are not. One of them, which is very, very important when you're dealing with Justice Court in Arizona, is be on time. We have seen numerous cases where there's a 10 o'clock hearing set for an initial hearing. The case is called for Mr. Smith at 10:05. Mr. Smith is not in the courtroom, and a default judgment is then entered. Mr. Smith shows up at 10:15 and says, "Judge, I'm sorry you're late." And before they go any further, too bad, so sad, folks. You were late. Default judgment has been entered. You're going to have to see if you can find a way to undo it by filing a motion to vacate. Well, that's not going to happen. Judges, bottom line is if you are not there when the case is called, you are going to end up with a default judgment against you. And the next step after the default judgment is a writ being issued by the court to have you be removed from the property. It is important to note that default judgments are not appealable. So again, it's best if you show up on time. If you are going to show up to an initial hearing by phone, make sure that you call in at least 10 or 15 minutes ahead of time to make sure that you get through. And once you are connected and you know you're connected, you need to basically remain silent until your case is called. Once your case is called, make sure that you speak up so that the court knows you're there. Again, if the court doesn't know that you are there on the phone, they will enter a default judgment, and then you're back in the same position. Let's go to the next one, please. Okay, this is Judge Judy all over it. Bottom line is, whether you're on the phone or in person, be respectful to the court. Bottom line is that you don't want to interrupt the court. You do not want to use foul language with the court, address the court as a judge as your honor. Do not speak over the judge. Do not speak over the other attorney. If you have a point to make, you will be given the opportunity to do that. But it is very, very important that you be respectful. If you are not, and judge hears what you are saying under your breath or to somebody else in the courtroom, it impacts how a judge views you. So make sure that you are respectful. If you are appearing in court in person, make sure that you are dressed appropriately. I've watched people come in tank tops and cutoffs. Not a good look for court. So please make sure that you guys, are mindful of that. That's my Judge Judy speech portion of it. Let's go back and go to the notice of breach. Okay, so the process generally starts when you get some type of notice from the landlord. The Landlord-Tenant Act requires there be notice to the landlord, and you have certain rights once the notice is issued before the landlord can file the lawsuit and serve you with a summons. So there are a few different things. There's one with a 10-day right to cure. Those are usually things where you have violated the lease by, let's say, using the pool after hours, leaving trash on your patio, things that are not horrible, serious violations, but do violate your lease. Landlord will give you what's called a 10-day right to cure, which says, here are the bad things you've done, please take care of them. If you take care of them within the 10 days, that's as far as it goes. If you don't, then they will they will file for an eviction and take you to court. The next one is a 5-day notice, which is required for the landlord to give you when you don't pay your rent. If you cure within the 5-day time period, that takes care of it, and you will not end up with an eviction action being filed. Please make sure if you do cure it that you have proof of the payment. Get a receipt or pay by check, something where you can show that the payment was actually made. If you don't take care of making the payment, you'll again be served with a summons and complaint, and you will end up in court where your rights at that point change. The strictest one is the notice that you get that says you have done something really bad, drugs in the apartment, assaulted somebody on premises, things that you know are real bad. Usually they rise to the level of criminal acts, are called material and irreparable breaches. You do not get a right to cure those. You will get a notice which requires basically that they're telling you you're going to get an eviction and be in court within a matter of a couple of days. And then you are going to have a hearing right at that point. So it is important on all of those that you know that you have certain rights to cure, except for immediate where there is no right to cure. Okay. On the right to bring rent current, where you have the 5-day right to cure, you have the 5 days prior to the eviction being filed. Once the eviction is filed, you can cure once you go to court, but you're then going to have to pay some additional charges and fees. But if you do cure it when you're in court, the eviction judgment will not be entered against you. Okay, let's talk about next slide. Okay, so we're now on, you've gotten past all these initial notices, you haven't cured, the lawsuit's been filed. Let's talk about what's going to happen next. The landlord will file a lawsuit, and the court will issue a summons. The summons and complaint will then be served upon you. There are different ways that it can be served, but most important thing that you need to know is that on the sheet that is entitled summons, it will tell you when your initial hearing is, the date and the time, and how you can appear by phone or in person, etc. Again, this is the time where you know you have been sued and you need to act immediately. Let's go to the next slide. Okay. So we talked earlier about the immediate eviction. This is for stuff that rises to the level of criminal, and the hearing happens within a very, very short time. On the ones that are not immediate, you usually have an initial hearing, and then the court will then set it for trial a few days out. That is not the case on immediate eviction. On the immediate, your initial hearing and your trial will likely be at the same time. You go in front of the judge, you will plead guilty or not guilty. If you have a basis to file a motion to dismiss, which we'll talk about later, the judge will likely rule on it at that time. If you plead guilty on an immediate eviction, the judge will issue a writ directing the sheriff to remove you from the property within 12 to 24 hours. If you plead not guilty, the judge will usually have trial right then and there. The reason it is important to know that is that if you are going to plead not guilty, you have to be prepared to put on your trial that same day, which means you need all your paperwork and you need all of your witnesses to be present to be able to put on your trial. Very important. I'll say it here, but it's also important for any time else you go to trial. First of all, there's no fee for filing an answer if you're going to contest the eviction. But one of the very, very common mistakes that is made by lay people in court is something that Judge Judy again jumps over all the time, which is people say, well, Your Honor, I have a written notarized statement from my next door neighbor. And Judge Judy says, I'm going to stop you right there. I'm not taking written statements from your neighbor. They're hearsay. If you want your neighbor to be able to give that information, your neighbor has to be here in person and give testimony. So again, very important that the witness be present. A notarized affidavit without the witness there will not get admitted by the court. And the reason is pretty simple. The other side, the landlord's attorney, is supposed to have a right to cross-examine the witness as part of a trial. If the person is not there, then there's no ability to cross-examine. So please understand that written notarized statement is not going to be allowed. Okay. Again, if you're in the hearing right at the beginning, if you have a basis for a motion to dismiss, file it and argue it at that time. If it is granted, that means you will not need to go forward with your trial. And if it is granted for various reasons, at that point, you can ask the record be sealed. One of the things that I will raise at this point, but applies again to the other types of eviction, is if you have vacated the property, then the eviction hearing does not need to go forward. An eviction hearing primarily is to determine whether the landlord has a right to possession of the property. So if you have vacated the property prior to the hearing, there's no reason for the hearing to go forward. The key issue here is what constitutes vacating the unit. And vacating is not just, I told the landlord I'm gone. Vacating doesn't mean you left the keys on the counter. Vacating means that you have done what you're supposed to do to leave the unit. You have locked it up. You have delivered possession of the keys to the landlord. And most importantly, that you have proof that you did that. So if you are going to deliver your keys to somebody at the office, get a receipt or bring a witness with you who can testify that you delivered those keys. When you go to the other types of, and let's go to the next slide, Pam. Okay, so if we don't do an immediate eviction, if we're going to the one where where there was a 10-day notice or where there is a 5-day notice, so you're talking non-payment of rent, you will have an initial hearing within 3 to 6 days from the summons. If you plead guilty, you will get a judgment entered, and then a writ will issue 5 days later for the sheriff to remove you. Be aware that in justice court, if you are in there because of non-payment of rent, and the judge asks you, did you pay the rent for March and April, and you say, no, Your Honor, but you're not going to get any further than that. As soon as the judge hears that you are behind on your rent, the judge is not going to want to hear anything further. They are going to enter a judgment against you and then order that a writ be issued. It's very difficult to defend against non-payment of rent. Again, you do have the right up through the point that the judgment is entered to bring the rent current, so you can bring it with you to court along with the charges and attorney's fees and the other stuff that's needed to bring the past due amounts current. And at that point, the eviction would be dismissed. If you plead not guilty on at the trial, that the hearing, the initial hearing, likely what will happen is the court will set a trial within the next 3 days. Most of the time, they do not set it the same day. If you lose a trial, again, you're going to end up with a money judgment against you, as well as a writ issued to have you removed from the property within 5 days. Good. Excuse me, next slide, please. Okay, so we talked a little bit earlier, and I'm sorry, I'm gonna go backwards a second on something we don't have a slide on, so you don't need to change it, Pam. We talked about if you're gonna go to trial. And again, we talked about trial, make sure your witnesses are there, make sure your documents are there. The general trial is set up so that the landlord gets to present their case first. They will present whatever information and witnesses they have. You, as the tenant, either on your own or through your attorney, will have the opportunity to cross-examine the witnesses, which means you get to ask the witnesses questions to find out and whether what they're saying is accurate, or if there's additional information that you want to elicit from them. That is the time that you get to do that. You do not get to present your evidence at that point in time. Once the portion of the trial is done where the landlord has presented their witnesses and you've cross-examined, you will then get to present, excuse me, your own witnesses. Again, important that the witnesses be present, that you have your paperwork present. And once you present your witnesses, the landlord will have the opportunity to cross-examine those witnesses. And then after that has occurred, the court will enter a judgment either for the landlord or for the defendant. If the judgment is entered for the defendant, which is the tenant, you can ask that the case be dismissed and that the record be sealed. Okay, now we're going to come back to the portion on motion to dismiss, which I talked about earlier. If you have a basis for a motion to dismiss, it should be made, if at all possible, at the initial hearing. And what you're doing is basically saying to the court, there are these reasons why this matter should not go forward, either in the initial hearing or the trial, because the court doesn't lack jurisdiction. As an example, Your Honor, I vacated the property. This hearing is all about possession of the property. I have proof here that I have turned in the keys. They accepted that, so there's no jurisdiction here because possession is not an issue. Or you can do, Your Honor, the rules require that notice, the 10-day notice that they were supposed to give me, they did it wrong, or they didn't have the case properly served. Here's the proof. If they haven't properly served me, we can't move forward. The tenant has vacated, we talked about. The other one, which is fairly common, is where the landlord has accepted a portion of your rent, but has not gotten any type of written agreement in place with you as to how the remainder of the rent is going to be paid. That's a partial payment defense that should also be raised. And again, these are all technical things. We're not going to get very deeply into them, but you need to be aware that they exist. Let's jump to the next slide, please. Okay. So now we're at the point where there's a judgment against you. Okay. I'm going to go back and reiterate. If it is a default judgment, which means that you did not appear for your hearing, the court will enter that judgment and you are going to have a very difficult time at that point because that is not an appealable judgment. There are some other ways you can go about it, but do be aware default judgment is difficult to get to undo. Post-judgment, you can move, you can vacate the property prior to the writ being issued. We talked about the writ as something where a judgment is put in place and then the court orders a writ directing the sheriff to remove you within a certain period of time. If you can show that the property has been vacated prior to the writ being issued, then the writ will not issue. You'll just have moved out of the property. always advise people when you move out of a property, make sure that you photograph everything in the property to know so you can prove what the condition was at the time you leave. Another option is post judgment. You can pay the judgment in full. If you do that, make sure that the landlord files something called a satisfaction of judgment. Very important because that'll help clear up the record so that you can uh, be able to rent from another landlord. It is important that you know that paying the judgment after it is in place does not give you the right to remain in the property. It does not reinstate your lease. It does not give you the right to go back to the property. That is something that the landlord would have to agree to with you and again put it in writing. All payment of the judgment itself does without a written agreement with the landlord is allows you a satisfaction of judgment. Let's go to the next one, please. Okay. The other option post judgment is you can file for an appeal. Few different things to know here. Number one, many people think that if they appeal, they're going to get a whole new trial. That is not the case. Appeal is very simply you saying to the court that the trial court, which is the justice court in this case, has messed something up in the way that they ruled on the case. It is not going to allow you to present new evidence, new witnesses, or make new arguments. It is only allowing you to go in front of an appeal court to say the court's ruling was wrong because it was a misinterpretation of this law, or the court declined to allow certain evidence in which I tried to present, and you'd have to give the reasons why that was improper and then argue that before the appeals court. Timing with an appeal is very, very essential. The rules say that you have 5 calendar days, not business days, calendar days to file a notice of appeal. If the 5th day lands on a weekend or a holiday day, then you can file the next day. When you file the appeal, court is going to ask for what's called a cost bond, which there is a provision to ask for that to be waived if you can't afford it, and also something called a supersedeas bond, which is a bond to cover whatever the amount of the judgment is. So if they awarded 2 months worth of rent that you presently owed, they're going to want a supersedeas bond for that rent amount. You are going to need to have that supersedeas bond in place in order to keep the writ of restitution from being issued to have you kicked out of the property. Without that, they will move forward with the writ. You also need to know that while the appeal is pending, which is usually a 60-day period, you are going to have to pay your regular rent into the court. Again, there are other time limits that apply, so make sure that you take a look at the rule, because once that notice of appeal is filed, and assuming you've done what you're supposed to with the bond and the rent, you have certain time limits that apply for you to file a appeal memorandum with the court and do certain other steps that get the appeal properly in front of the next level court. Okay, let's go to next slide, which is the final. Am I doing okay on time, Pam?
You're doing great. Great, Jeff.
Okay. Okay, so motion to vacate is much different than an appeal. Appeal, again, is going back to looking at certain mistakes that may have been made by the court in interpreting the law, etc. The motion to vacate is after the judgment is in place, going back and arguing, much like on a motion to dismiss, the court may not have jurisdiction, there was improper notice, things along those lines. The good thing with the motion to vacate is it is not as strict a timeline as the appeal. You get There are some short timeframes, I believe it's 30 or 60 days, and some that are longer, but you can go back to the trial court, which is the justice court, and say, these are the things that were improper, and you're allowing the case to move forward. If the court agrees with you and grants the motion to vacate, you will want the record sealed so that it shows that it's dismissed, and that will help you move forward with being able to rent another place if they, or potentially going back into the unit you were in. I think that's it, Pam. Is that the last slide? Okay. This is just something to be aware of when you go in. A lot of times, people come in on behalf of the landlord who do not have the right to represent the landlord in court. If somebody shows up there who does not have the right to make the presentation to the court, you can ask for the matter to be dismissed. The court may either dismiss it, or the court may continue it a couple of days and tell that person, you can't be here representing the landlord in this matter. You need to get the landlord, the owner of the property, here. As you see in the last line of the slide, a property manager cannot represent the landlord in court. So it's a method to potentially slow things down or maybe get it dismissed. It's a technicality, but the courts are aware of this rule. And I think that may be it. Okay, so here's information about how you can reach us both in person and online. We have time for questions, Pam, or no?
We do have time for questions.
Okay.
You can just put them in the chat if you have questions. And if you're watching this video, you can email us with general questions. But the good news is I apologize to everyone. Oh, we do have some Q&A. Okay, are you ready? I found some. Somebody would like us to review a motion to set aside a default judgment I draft. Please email me directly about that and we can talk about it. The next question is, how do you file an eviction answer prior to judgment? What are the steps?
Okay, as a layperson, the easiest way to go about this is you go on the Justice Court website, and they have a form that you fill out to provide an answer. And usually, if you take a look at the lawsuit that's been filed against you, it comes with the summons. There's a document called eviction action or eviction complaint, and it lists various items on there by 1, 2, 3, 4, 5. There's usually about 5 or 6 different items that they list, and they are numbered. When you file your answer, follow that same guideline, and you put down number 1 in response to item number 1 of the complaint. I admit or I deny. Same thing on number 2, and go straight down that list and follow the order that the complaint is written in, and that will get your answer in. You then file it with the court, and you send a copy to the opposing party, whether that's the landlord or their attorney. Anything to add on that, Pam?
Nope, that's great. Are the courts required to provide interpretation? Can we request an in-person interpreter?
Yes.
Is a notice posted on the door, not hand-delivered to the tenant or mailed, considered legally or not legal by the court?
It is considered legal, but it has to be both posted and sent by mail. There is a what's called a post and mail rule that if there's an affidavit in the file by a processor that says we both posted the summons and complaint and mailed the summons and complaint, that is sufficient.
And I'm not sure about this question. I think they're asking, can a power of attorney represent a landlord?
Generally, no.
All right, that is all the questions we have. Thanks, Jeff, for answering those.
Right. And again, everybody, I'm going to emphasize the thing about do not be an ostrich. The sooner you get help, the better, especially when you're dealing with our office. We have
Yeah.
much better success if we have some time. We have relationships with all of these landlords' attorneys. And if we call ahead of time and there's a basis to talk about reaching an agreement, giving us the time to do that, usually ends up in a much better result than if we are brought in the very last minute.
Absolutely. Thank you, Jeff. I really appreciate all your expertise. We will put this on our YouTube channel and share it. So thank you.
All righty, thank you, everybody.